Mr. President, we are here to discuss Solicitor General Elena Kagan's qualifications for the Supreme Court. And we've heard a number of conversations from our colleagues who are themselves lawyers, who have sat in on the Judiciary Committee, and who have gone through the record with great detail. As I've said here before, I'm unburdened with a legal education. I have great respect for those who have been taught to think like that and talk like that and who go into that kind of detail. But I view this from a slightly different point of view, and I hope it's a common sense point of view, and I'd like to share it with my colleagues here this afternoon. And I go back not to start with Miss Kagan, but to start with an incident that occurred when we were discussing the possibility of John Roberts going to the Supreme Court as the Chief Justice. In that period of discussion, there was a particular case that was raised in the press where John Roberts had issued a ruling that, according to the newspapers and the reporters, was an egregious ruling. Here are the facts of the case. There was a young woman riding the metro who ate a French fry. Not a lot of French fries, a French fry. And she had the misfortune, she was 12 years old, and she had the misfortune to do that in the presence of one of the security officers of the metro who arrested her for violating the publicly advertised zero-tolerance, no-eating policy on the in a Washington metro station. She was not just detained, she was arrested, searched, handcuffed, driven to police headquarters, booked, and fingerprinted. 3 hours later, her mother showed up at the police station, and she was released to her mother, and she sued, alleging that she was treated improperly, that an adult would have only received a citation, and that this was a terrible thing that had been done to her. The law says that children who violate this policy have to be retained until their parents can arrive. Well, Justice Roberts, the case finally came to him on the circuit court, ruled that the metro people had acted properly. And in an attempt to derail his confirmation to Chief Justice, there was a dust-up in the newspapers and the media. This is a man, we want to put him as Chief Justice of the United States, and he will tolerate this kind of treatment of a young woman who does nothing more than eat a single French fry in a metro station? That's the kind of man we want on the court? I remember those kinds of editorials and op-eds and denunciations that were made of Mr. Roberts. Then the facts came out as they got into what really happened. What I have said are indeed the facts, but this is what Justice Roberts said when he handed down his opinion. He said, no one is very happy about the events that led to this litigation. He said it was a stupid law. He didn't say it in those kinds of terms. He said it in proper legal terms, but basically the burden of what he said was a stupid law. But he said the question before us is not whether these policies were a bad idea, but whether they violated the Fourth and Fifth Amendments to the Constitution. And then Judge Roberts concluded that they did not violate the Fourth and Fifth Amendments of the Constitution. And interestingly, the City Council, in response to the things he had to say about the issue, changed the law. So he made it clear, I don't agree with this law. I think it's a bad law, but that's not my responsibility. My responsibility is to determine whether or not it violates the Constitution. This is reminiscent of Justice Potter Stewart's dissent. In Griswold versus Connecticut, he said, we are not asked in this case to say whether we think this law is unwise or even asinine. We are asked to hold that it violates the United States Constitution, and that I cannot do. Well, what does that have to do with Elena Kagan? She was faced with a similar situation. She was not a judge, but she was in a position of authority, and she was faced with a law that she decided was a bad law. This was the Solomon Amendment, having to do with the question of military recruiters on college campuses. She was in a position, as the dean of the law school at Harvard, to prevent military recruiters from come on campus. Now, the Solomon Amendment, that was the law, said you can't do that, Dean Kagan. You may disagree with the military's policy with respect to don't ask, don't tell, and you can do that. You can even express your disagreement in a legal fashion, and she did. She openly opposed it. She joined other faculty to sign an amicus brief in support of a constitutional challenge of the Solomon Amendment, and I do not object to that. She has every right as an American citizen to challenge something that she thinks is inappropriate in the law. But she does not have the right to flout the law and to say, no, we won't do it. And when she became the dean at Harvard, she did that. She refused to allow the recruiters to come on the Harvard Law School. And she says she didn't. She says, no, they had full access all of the time. So it becomes, by the way, she was wrong on the law as far as the Solomon Amendment is concerned, because the Supreme Court decided unanimously that the Solomon Amendment was constitutional and that the military had the equal access to student or federal funding institutions. So she should have said, all right, I had my day in court, I lost, I'll comply with the law. No, she didn't. And this is what the recruiters said. She says they had full access. All right, if they had full access, I would think they would confirm that they had full access. But this is what they had to say. The Army's report from spring 2005 said the Army was stonewalled at Harvard. Phone calls and emails went unanswered, and the standard response was, we're waiting to hear from our higher authority. There's a Defense Department memo. Denying access to the Career Services Office is tantamount to chaining and locking the front door of the law school, as it has the same impact on our recruiting efforts. The chief of recruiting for the Air Force JAG Corps was repeatedly blocked from participating in Harvard's 2005 recruiting session. He reported, Harvard is playing games and won't give us an on-campus interviewing date. 3 different recruiters give a different view of what was done with respect to Harvard. And yet, General Kagan says, no. They all had full access at all times. If they did, then they are lying. If they didn't, then she is giving us false information. She denied the entire incident. I think their proper approach should be, I hate the Solomon Amendment. I think it's the wrong thing to do. But just as Judge Roberts upheld the action with respect to a 12-year-old girl that was clearly not appropriate because it was the law, I have a responsibility as a lawyer, and lawyers are officers of the court. I have the responsibility as a lawyer here at Harvard, even as I'm voicing my objections, to say the Solomon Amendment is in place and I'm going to respect it. She didn't respect it, and she denies that she didn't respect it in the face of testimony to the contrary from at least 3 different sources that were directly involved on the case. I don't find that the kind of behavior, regardless of my ideological difference with her, that I think a justice of the Supreme Court should have. She's had much the same attitude with respect to the Second Amendment, and she refused to declare support for the Second Amendment when she was questioned about it, just simply dismissing it as settled law. Going back to the Solomon Amendment, Wasn't that settled law? And when she had an opportunity there to act against it, she took that opportunity, feeling correctly that she would not be disciplined for it at Harvard. But now I don't think she can appropriately say she shouldn't be questioned about it as she's being proposed for the Supreme Court. She wrote, with respect to a plaintiff's contention with respect to the District of Columbia firearms status, as he said that the District of Columbia law violated his constitutional right to keep and bear arms, I'm not sympathetic. And she recommended that the court not even consider the case. The court has considered the case and has ruled otherwise. So she is going to go to the court, I assume she will be confirmed, with at least two circumstances where she's taken firm positions in opposition to the court she intends to join. In one case, it was a unanimous case that overturned her. It was not a 5-4 decision. My concern about her is that she has never shown any inclination towards impartiality. I don't mind people of strong opinions. This chamber is filled with them. I don't mind judges that have strong opinions, as long as they don't let those strong opinions get in the way of what the law says. And I'm afraid in her case, she is one who will let her strong opinions get in the way of what the law says, and for that reason I intend to vote against her.
Mr. President.
Senator from South Carolina.